Keeping up to date with laws establishing ethical standards for public office is critical for all local officials. The Illinois State Association of Counties is pleased to partner with the law firm of Mahoney, Silverman and Cross to provide this educational video that discusses topics like the Public Officer Prohibited Activity Act, the Freedom of Information and Open Meetings Acts, the Gift Ban Act, and how the holding of more than one public office may be improper under Illinois law. The Illinois State Association of Counties is dedicated to the promotion of public service and ethical, responsible, and responsive county government. We offer this educational video as an important resource and hope that it will familiarize county officials about their obligations and responsibilities under the law. For more information about the Illinois State Association of Counties, please visit our website at www.isacoil.org. Thank you.
Hello, and welcome to a presentation on public officers' ethical considerations, brought to you by the Illinois State Association of Counties. My name is David Silverman. I'm an attorney with the law firm of Mahoney, Silverman and Cross in Joliet. Before I get going, I'd like to thank Joe McCoy and also the board of ISACo for allowing me the opportunity to bring this presentation to you. I wish we could all be together in the same room, but unfortunately we can't. So we thought the best way to bring this information was through a Zoom recording. If you have any questions, please feel free to contact me. My phone number is on the slide, 815-730-9500, and also my email, dsilverman@msclawfirm.com. Feel free to reach out to me at any time. Before I get started in the presentation, just like to tell you a little bit about myself. I'm an attorney. I've been practicing law in Northern Illinois for approximately 34 years. Most of my clients are local government entities, cities, villages, townships. I represent civic centers. I've worked with sanitary districts, water districts, and also our firm does a lot of work with housing authorities throughout the state of Illinois. As always, as a lawyer, first off, we need to present the disclaimer. I've done my best to try to provide you accurate information, but as you're aware, when you work with the law and questions of law, many times facts interact with the law to provide differing results under different circumstances. So please be sure to check with your local state's attorney, your local counselor, your local ethics officer before making any decisions with regard to the information that we're talking about today. First, next, an overview of the issues. The Public Officers Prohibited Activity Act, interest in contracts is the first subject that we'll discuss. Next, we'll talk a little bit about the prohibited political activity. Using government resources and politics don't mix. Electronic and social media, how they interact with the Freedom of Information Act and Open Meetings Act considerations. The Gift Ban Act, the laws and practical considerations regarding gift bans, what can you accept and who can you accept quote unquote gifts from. And last, the incompatibility of offices. What makes some offices incompatible with others? And what I mean by incompatible is holding two offices simultaneously. In some circumstances, you can do that. In many, you cannot. And again, those issues are driven by facts and also many laws and attorney general's opinions on the issue. First, the Public Officers Prohibited Activities Act. This is, you can find this if you're interested in looking it up. It's 50 ILCS 105/3, and it comes from the local government section of the Illinois compiled statute. This deals with contracts or services that you may provide to the board that you represent. I assume that many of you are county board members or work for counties, so we'll direct these messages principally to county issues. These, the Public Officer Prohibited Activity Act addresses both legal issues and also you should put into consideration political issues. Many times you may be allowed to do business with the board that you represent, the county that you represent, You may be allowed to do that by the strict letter of the law, but also consider what this might look like and whether some might accuse you of having a conflict of interest, even though legally you don't. These issues are sometimes hard to explain because they deal with fine points of law. So before you provide any services or enter into any contracts with the county or with any board that you may represent, please be sure to give this very thoughtful consideration. One of my old law partners used to tell me the test is really not what it says in the law, but what it'll look like on the front page of the newspaper tomorrow. So I think that was good advice then, and it's still good advice. Think things through before you get involved financially with the board that you represent. Interest in most contracts with your public body is prohibited. A person holding any office, either by election or appointment, may not be financially interested in his name or in the name of other persons, trusts, associations, etc., in any contract or the performance of any work, in the making or letting of which he might be called upon to vote, or in the representation of another in a bid situation where you may be called upon to vote. So let's start to break that down a little bit. In your name or in the name of another. Some people get cute ideas and think that they can use a straw person, use that person to contract with the board that they represent. We've seen that a number of times. It doesn't work, and this statute clearly prohibits it. It's the performance of any work or any contract. So remember, in order to fall within the definition of the prohibited contracts in this act, you need not have a formal written contract. You just need to be providing services or something for value for which you are recompensed by the county in a manner in which you may be called upon to vote. And that's pretty broad. It's not necessarily voting on that individual transaction. It may be voting on the bills list that comes before the county board. Also in bidding situations, be careful. Don't try to help someone with a bid. Don't try to represent them or be at all interested in it. Exception number one. With any law, there are always a number of exceptions. And let's back up just a little bit. Some of the situations that we've seen where individuals are interested in a contract with their public body or entered into without malice, without any evil intent, but nonetheless drew the attention of the public or others and had to be dealt with. And several examples, just, a county board member who may run a gas station that has a contract to sell gas to the sheriff's office, tow companies who tow cars for the sheriff's office, minor repair services, computers work, IT people. We see this on occasion. And a lot of people say, well, look, I'm providing this service to the county, and I'm sure I'm being paid, but I'm doing it for a lot less than what somebody else would charge. I'm really doing the county a favor. That doesn't count. You need to follow the law, and while your intentions may be good and your intentions may very well be well-meaning, you could end up in a troublesome situation if you're not careful. So the first exception deals with the public officer who owns less than 75%. Less than 7.5% of a contracting company. And in order to make this exception work for you and to fall in the protections of this section, you have to publicly disclose your interest during deliberations on the contract or the agreement. So what do we mean by publicly disclosing? My recommendation is that it be placed in the minutes of the county board meeting where it's discussed. And talk to your clerk. Make sure you go back and make sure that the clerk has placed this in the minutes, that you've publicly disclosed your interest in this contract so that you're protected in case there are issues going forward. Don't vote. The public officer must abstain from the vote. That makes sense, and I'm sure it's something that you would normally just take for granted anyway, but be sure not to vote on it. The contract must be approved by a majority of people holding office. So this really doesn't come into play unless possibly you have a couple county board members that are missing or not there that day. You have to make sure that you have a majority of those holding office at the time and not necessarily just a majority of those who constitute the quorum at the meeting. If you own less than 7.5% of the company and the contract is over $1,500, it must be publicly bid. A lot of practical reasons why, just bidding a $1,500, $2,000 contract does not make sense from a financial perspective for your organization. And then what you do is you look at the fiscal year for which you've had the contracts or agreements with your board, and make sure that you don't have more than $25,000 worth of contracts in the aggregate in that same fiscal year. Exception number 2. Exception number 2 deals with the award of a contract for a person who provides materials or merchandise or other services, again, to the board where you represent, and you own more than 7.5% of the company. Might be a sole proprietorship. You and your spouse may own the company. Whatever situation you're in your, whether it be corporate stock, membership shares in a limited liability company, interest in a partnership, corporate, it doesn't matter what it is, but if it adds up to more than 7.5%, this is the exception that you're going to need to be looking at. Again, you must abstain from the vote, but you are included in determining whether there's a quorum present. The contract cannot exceed $2,000, and there must, again, be public disclosure on the record in the minutes of the meeting to be sure that you're protected. And you look at the fiscal year aggregate in this case, down from $25,000 if you own 7.5% or less to $4,000. So it's very limited in scope, and it's going to really have a severe limitation on the amount of business that you may do with the county that you represent if you decide to do that. Exception number 3, you own less than 1% of the contracting entity. Gets easier now. It's, your interest is significantly less significant. Any money that you would make from a contract or providing services with the county that falls under this exception 3 could be, most likely will be severely reduced or restricted. Again, you need a majority vote of the public body. You will not vote, but you will be counted in determining whether a quorum is present, and you must publicly disclose on the record the fact that you're entering into this contract. The statute contains several other exceptions. And again, like anything that you're dealing with, before you enter into this contract or consider entering into a contract with the board that you represent, make sure that you get some good advice ahead of time. The other exceptions include members of not-for-profit boards. If you sit on the board of a local charity and that charity has a contract with the county, for example, it will not be considered a legal conflict of interest. If it's a county-owned public utility and you have an agreement with them, also an exception, a very limited exception though. And if you have 1% or less in a publicly traded company. So again, this is kind of deals with your mutual funds, maybe 401k funds, if you have something like that. What happens if you violate this section? It's a class 4 felony, so it's very serious. It has very serious legal implications. You can be fined up to $25,000. You could be in prison from 1 to 3 years, and you may also lose your office. So it's important, and there are consequences. And if you have a situation where you're going to consider entering into a contract with the county, please be sure that you vet that ahead of time with your state's attorney, your ethics officer, whoever is giving you advice on situations like this. There's nothing worse as a lawyer representing a public body than to have one of the members raise their hand and say, well, Dave, this is my company. I own this with my wife, and I just want everybody to be clear that that I have, I'm going to enter into this contract. So is there anything wrong with that? Do you see a problem? That is not the time for your state's attorney or others to give you advice, because there's so many facts. Have you entered into other contracts with the county in the last fiscal year? What is the partnership arrangement? How much do you own? There are too many variables to put a question so important, where the risk is so great, to your state's attorney or others at the meeting. So be sure, if you're thinking about doing this, be sure that you discuss this ahead of time. Good facts, good information will equal good advice and keep you out of trouble. So where do you go for this advice? You might go to your county ethics officer. He or she may be able to help to decide whether you have a conflict. The state's attorney would be a good resource for you. If your state's attorney will cooperate with you and give you advice ahead of time, that's probably your best source. And again, on many occasions, I've directed people to their personal or business attorney. If I'm representing a unit government and somebody says, hey, I've got this contract, do you think it's a conflict of interest for me to do that? Remember that, that we as attorneys, sometimes representing public bodies, don't represent you, but rather we represent the public body, and that's who our advice is going to. And when the consequences are so serious as they are in this case, I think it's a good idea for you to consult your personal or business attorney to make sure that you're getting good, solid legal advice that you can rely on from your attorney. So just a few considerations before you enter into that contract. Next, let's talk about electronic communications and social media. How does the Freedom of Information Act and the Open Meetings Act relate to electronic communications and social media? Obviously, every day with improvements in technology, the ability to instantly communicate, the landscape for Open Meetings Act issues and Freedom of Information Act issues changes every day. There have been a number of court decisions. The Attorney General's office has issued a number of opinions. And I think that it's safe to say that the opinions of the courts and the opinions of the Attorney General all lean more and more and more towards transparency, towards public disclosure, and having the public be able to participate in meetings and avoid closed meetings. So let's look at the Illinois Freedom of Information Act and the public policy that's stated in that act. And you can find this, if you're curious, at 5 ILCS 140/1, and then it follows. But the public policy stated by the legislature in the act is, it tells us a lot about how it's going to be interpreted by the court. I'm going to just read it to you. All persons are entitled to full and complete information regarding the affairs of a government and the official acts as policies of those who represent them as public officials and public employees consistent with the terms of this act. So understand that, and also understand that the Freedom of Information Act is strictly construed by the courts. What does that mean? What does it mean to strictly construe something? That means that they're going to look at it in favor of promoting this public policy and in favor of disclosure of the documents, rather than in favor of keeping the documents away from the public. So what are public records? And I think it's important to note at this point that the Freedom of Information Act does not involve private communications which do not deal with the business of the public body. So if you're a county board member and you have a county board email address and your spouse, sends you a message that says, hey, please stop and pick up a gallon of milk on the way home, that's not going to be disclosed because it does not deal with the public business, even in spite of the fact that it's at your county email address. Same thing on a personal email address, same thing on a personal text. If it's personal and does not involve public business, the business of the public body, you don't have to worry about it being disclosed. But again, we always should be mindful of what we put in writing, because at times things do get disclosed. And especially if you're using, say, a county email address or a county domain or a county phone, Remember that the person who decides whether or not to release these things isn't necessarily you, but it's rather a Freedom of Information officer. They may interpret the act differently. I've seen people just disclose things without really paying attention to whether they're exempted or whether they should be disclosed. So when you put it in writing, always, it's becoming old to say this, I suppose, but remember that when you put it in writing and it goes out in the electronic domain, anticipate that it could be disclosed to the public at some point. So what's covered by the Freedom of Information Act? We talked a little bit about what's not covered, but what is covered. Records in the custody or possession of a public body or prepared by or used by the public body are presumed to be open for inspection. Again, this idea of strict construction. Things are presumed to be open, and you as a county official or as a public body have to demonstrate and have to overcome the burden of this presumption that it placed upon you that it should be open to the public. So can you use your personal email or personal text message to keep things private and not be disclosed to the public? The answer to that is no. The answer to that, maybe 5 years ago or so, probably would have been yes, because the act was construed a little differently back some years ago. They took more of an approach to look at whether the document was actually in the custody or possession of the public body, and not so much whether it is prepared by or used by the public body. And for some purposes, they have expanded the definition of public body to include you as a county board member or a county employee. So the answer to the question is no. And I'm going to read to you from a case that just came out a couple of years ago called the Better Government Association versus the City of Chicago. Some of you may have heard of this case. It gained a lot of popularity and notoriety, I guess. But it says allowing public officials to shield personal email accounts and text messages, to shield information from the public view merely by using their personal accounts rather than government ones would be an anathema to the purpose of the FOIA. Again, FOIA is intended to disclose the public records, and that is going to be the presumption, and that is what you should be aware of. So, again, texts and emails on your private account may be subject to FOIA, depending on what you say. If they deal with the business of the public body, then they are going to be subject to FOIA. So you've got your personal email account, for example, and say the county is considering an important zoning issue, and you've been contacted by constituents. They've sent you emails saying, I support this, I oppose this, please vote this way, please vote that way. And they send it to you on your personal email at home. Those things can be disclosed and should be disclosed if there's a FOIA request. So what happens? The county doesn't have your phone. They don't have your personal computer. What happens? What happens is this: your FOIA officer should reach out to you and ask you the question whether you have any communications regarding the subject on a private electronic device or private writing, a letter. Doesn't have to be an electronic communication. It could be a letter that was sent to you. Do you have any of these? And if you do, you should disclose those to somebody, to your FOIA officer, so that they can look at that and make a determination whether it's subject to any of the exceptions from the Open Meetings Act. Saw a case in Destin, Florida, not too long ago. It's a place where I vacation a lot, so I kind of look at the local newspaper, and one of the city council members in Destin was actually arrested because she refused to, and removed from office by the governor because she refused to turn over private emails concerning a development in the community. So the story gets long, and as you might guess, pretty involved, but the police show up at her house with a warrant. There's I guess a bit of a discussion as to whether or not she needs to comply with this, and she ends up being taken to jail, and she lost her position as a city council member. I just read in the paper the other day that she has settled the criminal things without pleading guilty to any felony, so she's now asking to be reinstated. So let's don't go to those extremes. When your FOIA officer says, do you have anything? Let's tell them what you have, let's get them to it, and let's make sure that they do a good analysis of whether it should be disclosed. Again, always be careful what you write, almost goes without saying now. We had a case in Champaign that really started a kind of a chain reaction in terms of the interpretation of the Freedom of Information Act and the Open Meetings Act and everything else, how they relate to electronic communications. Down in Champaign, there was, as I recall, a couple of city council members who were communicating with each other during the meeting about the business that was going on at the meeting. And they defended it, said, look, you know, these are private messages between the two of us. In the courts determined that no, these were messages that you made. You were actually carrying on a discussion during the public meeting, so these are going to be subject to FOIA. So it was a long fought case by the city of Champaign, who defended it and tried not to release it, but they eventually lost. So bottom line, text messages, electronic communications, letters, whatever you have, are going to be subject to FOIA, whether or not they are on personal and private accounts. Most common exceptions to FOIA. There are a number of exceptions, and they can all be found in the Act. But if we talked about all the exceptions, we'd probably be here all day just talking about that. What do you need to know about the exceptions? One, you need to know that your FOIA officers are properly trained and understand the implications of all of the exceptions and how to deal with the exceptions in a good, professional, and most importantly, legal way. We still see a number of public bodies who don't really follow the law when accepting things from FOIA. You've probably all seen the pages that are blacked out or where the text is obliterated. And sometimes they just, obliterate the text, black out the text, and hand it over with no explanation as to why they did that. It's important to remember, and your FOIA officers should always remember, that they have to say why these things were exempt, and why the county believes that they are exempt from FOIA. And that has to be told in writing with a response to the person requesting the information. You also have to tell them about the remedies in the event that they don't agree with the determination that's been made by the county FOIA officer. And there are consequences, again, to not properly responding to a FOIA. And counties, municipalities, public bodies are not immune from those consequences. And from a legal perspective, the most important consequence is that if you make a denial under the Freedom of Information Act, and that ends up going to court, in that case, the county or your public body that you sit on is responsible for the attorney's fees for the requester if they prevail in this action. And that has happened in the past, and it will continue to happen. So always be careful. And what are the remedies when somebody requests something under FOIA and they're denied? They can appeal that to the Illinois Attorney General's office, who has a staff of lawyers who do nothing but FOIA, and they can make a determination as to whether or not that should be released. Or you can go to court. If you go to court as a requester who's been denied, then you have the right to attorney's fees, and you also have the right to a court order, which requires the disclosure. So again, the exceptions, an unwarranted invasion of privacy. And this deals under FOIA with several issues, all the way from traffic accident reports to personnel files, police investigations, things like that. I kind of put it under the broad umbrella of unwarranted invasion of privacy. Personal information, so anybody's personal cell phone number, their personal telephone number, any biometric identifiers are all exempt from FOIA, so be careful of that. I think what the most important exemption is for a public body is what we call the deliberative process exemption. So this really first developed under the Federal Freedom of Information Act, and then found its way into the State Act. And really, what does this do? it allows you to protect from public disclosure preliminary drafts, notes, etc., where opinions are expressed and policies are formulated, unless publicly mentioned by the head of the public body. So you can't have the county board chairman go out and talk about this correspondence and then tell the public they can't have it. But if it hasn't been publicly discussed, it's a really, really, really important tool for you, because you might want to send a note, an email, for example, to one of your planning staff, if you have zoning planning staff, or your financial officer, asking questions that assist you in making your determination of how to vote on a particular thing. So you're working on policies. How are policies determined? Well, they're determined through a deliberative discussion process. And the legislature and the courts have consistently found that this deliberative process to come to a good conclusion at the end should not be subject to public scrutiny. So make sure that your FOIA officers are aware of that. Make sure that you appropriately word up maybe a request to say your planning department. I'm really trying to make a decision on this case. Can you help me? What is the policy? How are we going to change the policy? Things like that. So use it to your advantage when you can. But again, always remembering that it may at some point be disclosed. So be careful what you write. The Open Meetings Act. Well, it used to be clear, if we were having a meeting or not, because there might be the proverbial smoke-filled room full of county board members, municipal officials, housing authority members, whatever they are. And, we knew they were having that meeting because you could see the smoke coming out from under the door. Well, it doesn't have to be that. And it is not that anymore. With the electronic communications, we're going to talk a little bit about how electronic communications, instant messaging, text messaging, even emails can be considered a meeting. But what does the Open Meetings Act prohibit? Generally, it prohibits communications concerning the business of a public body among a majority of a quorum, unless at a properly called meeting. And again, interactive communications may constitute a violation of the Open Meetings Act. So if we have, what I mean by interactive communications is you're texting back and forth, you're within pretty much the same time frame. And I don't know how far that time frame goes out, but make sure that, you're not texting back and forth with other members of your public body that would constitute a majority of a quorum of the members. So it's not a quorum, it's just a majority. So if a quorum is, for example, 7 people at the county board, then your majority is 4. So you can't discuss it among 4 members. And also remember, the Open Meetings Act not only applies to county board members in their capacity as a county board, it applies to your committees that you have. If you have county committees, then it applies to that. And again, when you look at the majority of the quorum, it's not the number of county board members that you have, but it's the number of committee members that you have. So in most instances, the number of persons that you can communicate without violating it begins to shrink. You might have a committee of 5. So majority of quorum would be 3, and majority of the quorum would be 2. So be careful what you do. Do not violate the Open Meetings Act. And I think a lot of times, you might want to send an email to all of your county board members, for example, and rather than send, 8 or 10 or 15 or 27 different emails out, you may want to send it to them at once, but you certainly do not want to violate the Open Meetings Act. So my suggestion is, if you decide to do that and it's appropriate to communicate in writing with your fellow members, here's what I would do. I would first of all write in all caps, please do not respond to all. We don't want to violate the Open Meetings Act. Always remind people, because we don't think about it. Maybe it's Sunday afternoon and you get an email or you get a text and you don't think about, well, I'm going to violate the Open Meetings Act if I respond to this email or respond to this text message. So remind everybody. But I think an even better tool, that was suggested to me some years ago, and it was almost obvious once it was suggested, is when you send these things out, instead of CCing everyone or sending the message directly to all the members of the county board, send it to yourself and blind CC the members. That way, they can't click reply to all, and you truly greatly reduce the possibility of violating the Open Meetings Act. So can you communicate with other members of the public body in writing or in discussions? Yes, as long as it's not a majority of a quorum, as long as you don't have this contemporaneous electronic communication. Again, use the blind CC and be careful responding to all. So, does that mean, you can't go out and have a cocktail after the meeting with fellow board members? No, that's not what it means. And you can all go out together. But the one thing that you have to be careful of is to not discuss the public business while you're enjoying one another's social company. And it's sometimes hard to do. I've seen circumstances where a bunch of people gathered at the bar after the meeting and started talking about the public business. Whereupon I left. I went home. I said, "Look, you guys, you shouldn't be doing this, and you're kind of on your own." The Gift Ban Act. The Gift Ban Act arises from the State Officials and Employees Ethics Act. It's 5 ILCS 430/1-1. And it was adopted some years ago in that state legislation also required that that units of local government adopt the Gift Ban Act, which are at least as stringent as the state law is. So remember that if you're looking at the local government's act, or you also have to be familiar with your county ordinance or any county policies that you may have, because the county may be more stringent than what the state law is. The state law sets forth only the minimum requirements. So check your county ethics ordinance to make sure that it's not stricter than the state act. So you can't receive a gift, and we'll talk in a couple minutes about what a gift is. But you can receive the gift right from your mom or dad or brother or sister. You can get a Christmas present. Who can't you get a gift from? You can't get a gift from what we call a prohibited source. Now, what's a prohibited source? A prohibited source is a company or a person who is seeking official action with the board you represent. They're doing business with you, or they're seeking to do business with you. The thought is that, a favor or a gift bestowed upon you may influence your decision. So remember, and also the agent, spouse, or immediate family of the prohibited source is also a prohibited source, if you will. It sounds a bit redundant, but you can't say, well, look, John wants to be the county's IT consultant, and he offered to give me a $500 ticket to go see Hamilton in Chicago. I said, no, you can't do that. So his wife gave it to me. Not going to work. Also, not going to work if he gives it to somebody else in your family, because under the Gift Ban Act, not only does the Gift Ban Act apply to you, but it applies to others. And we'll talk about that in a second. So what constitutes a gift? Cash, obvious. Food can be a gift. There's some exceptions we're going to talk about. Drinks, honorarium for speaker engagements, a gratuity. Somebody gives you something for nothing. It's generally not giving you something for nothing. They may be looking for something in return. A discount. If you receive a discount, you go to buy tires for your car, and it's from the same place that supplies tires to all the public works cars or trucks or the sheriff's fleet, and they say, well, we're going to give you a discount. It's a gift. Beware and make sure you make the proper analysis. Entertainment. When they first adopted the Gift Ban Act, golf was excluded, which tells us, I guess, a lot about what the people in Springfield had on their minds, but golf was originally excluded. Now it's not excluded. So even, someone taking you golfing can be a violation of the Gift Ban Act. Entertainment, as I said, hospitality, again, that's kind of the food and drink, the golfing type thing. Loan or forbearance, if somebody is going to loan you money on extremely favorable terms or doesn't expect to be paid back for that loan, it is a violation of the Gift Ban Act. And again, any other item which has a tangible value, just about anything is going to be covered by the Gift Ban Act. And who does it apply to? As I mentioned, it doesn't apply to just you. It applies to the elected officials. It applies to employees who make decisions concerning this prohibited source. And it also applies to spouse and immediate family living with the elected official or employee. So be aware that if somebody tries to give something to your spouse, to your daughter, to your son who lives with you, that could be a violation of the Gift Ban Act. And I would warn them to be careful who they accept gifts from. So what are the exceptions? And there are a number of them. And again, your county ethics officer should be able to assist you in making these determinations as to whether or not it's appropriate to accept a gift. Or if you have accepted a gift, and we'll talk about this in a couple of minutes, what do I do? I think I violated the Gift Ban Act. How do I cleanse myself from that? So it doesn't violate the Gift Ban Act if it's available on the same conditions to the general public. So if your tire dealer says 25% off a set of 4 tires this week, and you go in there and that coupon was available to the general public, not a violation of the Gift Ban Act. You pay fair market value. You really haven't gained any advantage at that point. So there is no gift. A lawful campaign contribution does not violate the Gift Ban Act. And I'm sure you're all aware, be careful with campaign contributions, be sure that there is no quid pro quo, and be careful and always appropriately report the campaign contributions. And I think that's one of the reasons that the campaign contributions are excluded, obviously, or can be excluded, is because they're reported if it's above $150, I think. So fundraising for a political candidate or cause is an exception. Educational materials, travel expenses, reasonable travel expenses do not violate the Gift Ban Act, or a gift from a relative does not violate it. Another one that gets a lot of consideration is a friend. If a gift is made from a personal friend, it does not violate the Gift Ban Act. So who are your personal friends? Is the engineering firm who's coming in wanting to do work with the county, and you've known this gentleman or this lady for a period of time, and you have somewhat of a collegial relationship with them. Are they your friends? Is this a gift, if they want to give you something, that's brought to you as a token of personal friendship, or is it a prohibitive gift, or a gift prohibited by the Act? What are we going to look at? We're going to look at the history of the relationship. How long have you known them? Is it truly a friendship, or is it an acquaintance or somebody that you've met on occasion? Did the friend pay for the gift? I would look at their consideration, maybe, did his company pay for it, and he's giving it to you then as a gift to be a so-called friend. Did the friend seek a tax deduction for the gift? Well, what does that tell us? It tells us that the friend is looking at it as a business expense, and what that would be is somebody trying to do business with the county. Again, he's via a prohibited source. Were gifts given to other officials or employees? I guess the question is, how many good personal friends can one person have on a county board? So are all gifts to you from personal friends prohibited? Certainly not, but they are prohibited if it's from that prohibited source, someone who's trying to do business with you, or if you're a county enforcement officer, somebody that you're going to interact with and may have to take enforcement action against. Okay, enough about what you can't do. What can you do? what is permitted, and kind of these are the big ones, right? Food and beverage, $75 per day consumed on the premises. So you can't walk into a restaurant and say, well, here's a $70 bottle of wine, take it home, share it with your family for Thanksgiving, right? You have to sit there, you have to enjoy it on the premises where it was sold or at a catered event. Food, beverage, transportation from outside business activities not connected to your official duties. Again, nobody's trying to influence you. There should be no problem. It should not be a prohibited source. Intra and intergovernmental gifts. So mayors may be exchanging things and like that would not be considered a violation. Bequests, inheritances, and transfers of death are not considered gifts under the Gift Ban Act. Obviously, if they were left for an inappropriate person, it could have other consequences, but not a violation of the Gift Ban Act. And $100, there's kind of a $100 exception in any cumulative year. So this is above and beyond the $75 for refreshments. This is $100 that you could get as a gift from a prohibited source in the case of a year. So, and you got to make sure you kind of keep track of these things. Who's giving you what. It's maybe somebody gave you a bottle of wine at Christmas. Do they again give you a bottle of wine at New Year's Eve? If it totals over $100, then it's a problem. If they give it to you on New Year's Day, may not be, because it's not in the same calendar year, although that's certainly not how I would recommend doing business. We've seen this. I can remember sitting in a room in a village hall working with a developer on a big store that was going to come into town, and we'd been working with him for quite some time. And at the end, he started handing out gift cards to everybody in the room, and and we said, look, we don't want these. We can't take these. What are we going to do with them? In this case, we told him we didn't want them. He insisted on leaving them there. So I collected them all from everybody in the room and took a witness with me and went to the shredder at Village Hall and put the gift cards all through the shredder. We tried to return them. They wouldn't be accepted as returned, so we destroyed them. So we did not, I think in a legal sense, accept the gift. If you have, if you have accepted this gift, say somebody mails it to you, and you've tried to return it and you're just not able to do it, that's going to be kind of a defense, if you will, to violation of the Gift Ban Act, or more importantly, and I think you can always return something, right? You can just ship it back to UPS to the sender. So I certainly would not be inclined to rely on that section to protect you. But one that does work, and I've seen it happen well, is you give the gift or its monetary equivalent to a 501c3 charity. So that doesn't mean that you get $200 tonight and then make your annual contribution to the charity of your choice that you always make a contribution to for $200 tomorrow. I always recommend that if you are trying to absolve yourself of a gift ban issue, you've gotten yourself into a situation, give it to a charity that you've never given to before. That way you can demonstrate that it's not your typical pattern of giving and that you are, in fact, attempting to cleanse yourself of this violation which has occurred. And I would also, as a practical matter, inform my ethics officer of what happened and how I took care of it. So again, this slide, my administrative assistant who happened to put this together is a big fan of the TV show Below Deck, and she actually got me watching it. So, what's a gift ban example? This is the obvious one, right? You go on a charter with Captain Lee and Chief Rachael on a $200,000 a week charter, and he provides for you everything that's on that boat. Well, that's obvious, right? That it's put in there more or less as it's so obvious that it's a joke. But some things are not as obvious, and they require that you pay close attention. How much were the greens fees at this golf course where somebody took me golfing? Sporting events, what's the price of the ticket? I think a one concern that I have is for people who maybe get sporting tickets to playoff games and such. And I'm not sure it's been ever tested with a court case, but you know what's really the fair market value of that playoff game? It may say $75 on the face of the ticket, but the person contributing it to you may have paid a lot more. So be careful what you do. If you do have a question, you think you may have a violation, again, go to see your ethics officer and also cleanse yourself by making a contribution to a charity. The Illinois Ethics Act provides a number of things that come down to local government through ordinances adopted by your county. And the Prohibited Political Activities Act is required by statute 5 ILCS 43017 to be adopted by units of local government. So your county should have adopted this some years ago. If you haven't, please talk to your county officials or your state's attorney about how you get this adopted. So, you know, what does this prohibit? There's just a whole lot of common sense that's set forth in this act. It virtually prohibits any activity relating to political campaigns or referendum or anything like that using any county resources in your case, or whatever board that you might sit on or be employed by. Don't use the phone in your office at the county building. Don't do it. Don't use the copy machine. Don't do anything that is political in nature in terms of a political campaign or a referendum using the county's resources. A lot of people get in trouble on this one, and you know, you use your cell phone, use your private email. If don't do it on company time, for sure. On county time, if you're an elected official, you're really not on the clock. So what I would recommend is, you know, when you get that call and you're at your desk in the county building, you know, take the call outside, walk outside the building and have the conversation. It's more private anyway, and you won't get yourself into trouble. Again, check your minimum requirements. Your county ordinance may be more stringent than the state law. You can't appropriate any county resources, any county property, any county employees for the purpose of doing your campaign work. You can't require an employee as a condition of their employment to do campaign work. They can't, the county employees can't do it on company time. Make sure that they take and this is important, well document vacation time, personal time. You may have a friend who happens to work for the county who wants to support your campaign and wants to work for you. That's fine. That's absolutely not prohibited, as long as they're not, one, you're not requiring them to do it. Two, you're not paying them any extra to do it. Or three, they're not doing it on any compensated time. They can participate on their own time. If they're going to go out and they're going to, you know, walk precincts for you on behalf of your political races, make sure that they well document that they're on vacation time or personal time. That way you don't have any problems. Incompatibility of offices. This is truly a broad subject, and I'm going to just hit on it a little bit so that you're aware of it, and you know, you kind of start to think about what do we look for. And really what incompatibility of offices means is that there's a prohibition, a general prohibition of holding simultaneously multiple offices. Sometimes it's okay, sometimes it's not. It depends upon the office, and it also can depend upon the law, perhaps how your state's attorney interprets the law. But there are both what we call statutory, which are written out in the statute, and common law conflicts, which can arise. So if you hold one office, for example, on the county board, and you're thinking about another office, you really have to dive into this and be sure that you're not violating anything. The legislature took a stab at this back in 1995, and they talked about units of government. So long as there's no contractual relationship, you can hold multiple seats. I'm not sure how much the Attorney General would agree with that statute, although we can all see what it says. Again, be careful. Check with people who you trust to make sure that they can assure you that you're not violating the incompatibility of offices provision, either from a common law perspective or from a statutory perspective, because you can lose your office. If you take that second office, generally the law is that you lose your first one. So if you're asked to sit on some other minor governmental board, you could lose your position if you're elected county board member. And this really doesn't apply so much to employees, but really elected officials. Common law conflicts, what do they look at? Does one have the power to appoint another to the office? Does one have the power to influence the other office? Spouses, the Attorney General's issued a lot of opinions. We hear a lot about conflicts. Hey, look, it's a school board, and that's where these cases generally come from. The wife is on the school board and the husband is a teacher at the school. Is it a conflict of interest for the school board member to vote on the contracts? And the Attorney General has said no. I mean, they're recognizing that, you know, that people are separate, and it sometimes baffles me because they go out of their way to find conflicts at times at the Attorney General's office. But in these situations, they've kind of gone out of their way to say that they are not conflicts. To me, you know, most marriages that I'm aware of anyway, there's a commingling of funds. And for example, my wife works as a school nurse part-time, and I certainly appreciate the income that she gets from that. So it's a bit confusing as to why they've said that one spouse voting on another spouse's position is not a violation. But again, I would certainly check on that because the law changes quite frequently in these areas. So I took this from a case that where above where it says note, it says, you know, the test, one of the courts has found that the tests of one office, the test as to whether or not offices are incompatible, as to whether the officer can do their duties in every instance, fully and faithfully discharge the duties of both of their offices. And that's the test. Hopefully it reads a little better than how I stumbled over it, but if you can always be fully and faithfully discharge the duties of both the offices, it's not a common law conflict, but again, it could be a statutory conflict. So there are many statutes which apply to this. The statutes say in some instances you can hold some positions, in some instances you can hold others. It might depend on the size of your county in some instances. So the information on the incompatibility of offices, again, I want you to be aware of it, be thoughtful about it, but there are too many twists and turns to really be able to get into it in a presentation like this. And it boils down to each matter must be determined on a case-by-case basis, understanding the facts, understanding what the duties of each office are, and understanding whether there are any cases that have set a precedent or whether the statute directs us. So always check with your state's attorney or other legal counsel or someone you trust before accepting that second office. So this concludes my presentation. Thank you very much for participating. I hope that you enjoyed it. If you have any questions, please feel free to contact me by email, dsilverman@msclawfirm.com, or by telephone at 815-730-9500. And again, thank you to the members of the ISACo board and to Joe McCoy for allowing me to make this presentation.